Thank you for having me, Katie. Are you seeing my screen okay? Excellent. Okay. So thank you, everybody, for coming. I hope that the presentation will be informative for you, and I look forward to the questions at the end of the session. Just a quick correction. As employers, human rights, workplace safety, and employment standards are three areas you need to know. But today, I'm just talking about the Employment Standards Act. So I'm with the Employment Standards Branch, and our job is to administer and enforce the Employment Standards Act, which sets out the minimum standards for employment in British Columbia. The Employment Standards Act consists of two parts. There's the Act and then there's the regulation. So the Act is the part that is debated and passed in the legislature. And then regulation is the part that tends to delve more into details, but more importantly, gets into the less permanent aspects of the Act. So any Act is typically it's quite onerous to change, often takes years to go through the entire process. Regulation is done just by cabinet, and so it's much easier to change. So you'll notice things like minimum wage, for example. The fact that you have to pay, or an employer has to pay minimum wage, is set out in the Act. The rate that minimum wage is set at, currently $15.65 an hour, is set in the regulation. So it's important to go together. And I have set in the chat, I've put three links in. One is to the Employment Standards Act, one to the regulation, and a third one to the Interpretation Guidelines Manual. So I invite you to copy those and to bookmark them. If you're not trained specifically in reading and interpreting legislation, then the Interpretation Guidelines Manual is extremely helpful. The Act and regulations are not hard to understand, but it's easy to overlook sections that apply to what you're reading that you might have missed earlier or later in the legislation. So the Guidelines Manual sets out both the Act and the regulation section by section in plain language, and puts out some fairly plain language, real life examples of how those apply. So it's used quite a bit even inside the branch. So first of all, who does it apply to? Well, first of all, under the Canadian Constitution Act, labor is primarily a provincial jurisdiction, but there are areas that are federal. So for example, banks are federal jurisdiction, international or interprovincial transportation are federal jurisdiction. So those would not be covered. If you don't know that you're federal jurisdiction, you're probably provincial jurisdiction, and this would apply. There's also certain occupations that are excluded from the Act that's set out in the regulation. Those tend to be professions that are self-regulating. So for example, medicine and law are two areas that are excluded from the Act as occupations. And then finally, it covers employees. So if it does not cover contractors, the person has to be an employee as defined in the Act. What is that? An employee under the Act is a person receiving or entitled to wages for work performed for another. It seems fairly straightforward, but if you have workers who work for you as subcontractors, you'll notice that this clause puts pressure up against that. So it's not uncommon for us to get complaints from people who worked as subcontractors, where they're being paid by the hour, but they did it as a subcontract. They liked it because they didn't have deductions on their paycheck, and the employer likes it because they're not having to pay payroll taxes. And then they either leave in unfortunate circumstances or not in unfortunate circumstances, but realize they missed out on some of the benefits that an employee qualifies for and a contractor doesn't. And they come to us with a complaint and say, really, was I an employee or a contractor? And in the vast majority of cases, they actually were employees. So this is something, if you have workers who get paid hourly for work done for you or your organization, be very careful about that. You're going to want to have a look at that. You may end up holding the bag later, which is not going to work to your best interest. The next definition includes a person an employer allows directly or indirectly to perform work normally performed by an employee. So I noticed there's some NGOs on the line. NGOs often have paid staff and volunteers. And what you see sometimes is in those kinds of organizations, a paid staff person goes on holidays and they're backfilled by a volunteer. Well, that person just became an employee. So for at least the duration that they're backfilling by this definition. And then third, it includes a person being trained by an employer for the employer's business. So this covers off the employers who like to say, well, we don't like to pay people for the training. It's already costing us money for the trainer and so on. And we don't want to pay wages on top of that. So if you successfully pass the training, then you become an employee. And this part of the definition says, no, they became an employee on day one that you started training them. And then finally, includes a person on leave from an employer. Now that it matters when you have somebody, especially on an extended leave, and they come back to work and say, I'm ready to go back to work. And you say, well, actually, we've moved on without you. And they file a complaint because you have just terminated their employment. So that's something to be aware of, and something particularly if somebody asks you for an extended leave or an open-ended leave, that you want to be careful of the vulnerability that's going, or the liability that's going along with that. And who's an employer? Employer includes a person who has or had control of or directed an employee, or who is or was responsible directly or indirectly for the employment of an employee. Well, it seems fairly obvious. When would we use this definition? Where we tend to see it used is where there is some confusion over which company. There's more than one employer on site, and there's some debate over which employer is responsible for the employees. So, for example, we see it on a construction site where the general contractor hires casual labor for a day or two or three, and then assigns them to work with the subcontractor. And then they go away, nobody's paid them, or they haven't been paid properly. They file a complaint, and the general and the sub are pointing at each other saying, it wasn't me. And this is the definition we use to determine who actually is liable in that case. And then what is work? Well, the definition of work includes the labor or services an employee performs for an employer, whether in the employee's residence or elsewhere. And work must be paid for, right? So whenever they do work, they're entitled to being paid for it. So you text an employee at home, ask them to do something, look something up, send an email, whatever, that's work. They're entitled to wages. An employee is on their way home, you ask them to stop in and pick up your dry cleaning or drop off your dry cleaning on the way because it's closer than where you live. That is work. Even though for you personally, it's not for the business, an employer just asks them to perform work. And so that they are entitled to be paid for that. I was asked about young workers. In most cases, under 14, you must apply for a permit to Employment Standards Branch before employing somebody under 14. If they're 14 or 15 years old, if it's light work, and that's described in detail in the regulation, so I'll point you in that direction, then you can hire them if you have written permission from the parent or guardian. It's really important with employment standards to understand that when it specifies written, there's no exceptions. You have 37 witnesses, but you don't have written, didn't qualify. You have recording on your phone, doesn't qualify. You have to have written permission or written documentation where it says written. This is one of those cases. If it's not light work, again, pointing you to the regulation for definition of that, then you must apply for a permit. 12 to 14 years old, no permit needed if it's light work and it's either a family business or it's sports and rec activity for youth. So for example, the day camp for kids, and you have a 13-year-old working at that, then simple written permission from the parent is sufficient. Same with family business. The thing to be aware of is part of the reason that there's these kinds of protections around young workers. It's not only to make sure they're getting a childhood and their education isn't being interfered with, but it's also somewhat about safety. And so just point out in passing with the family business, I don't know what the current stats are, but data that I looked at previously, 25% of young worker fatalities take place in family businesses. So it's the familiarity does not mean that they know how to do it safely, and you want to treat them with all due care and attention, despite them being family. So minimum wage, $15.65 an hour, was effective on June 1st, 2022. It's been going up certainly the last couple of years on June 1st. I would expect it to go up again next year. What's important to be aware of here is that with commission salaries flat rates, there's still a minimum wage that applies. So really quickly, there's some exceptions to this. So for example, a residential caretaker or a farm worker who's paid piecework, they still have minimum wage, it's just not this one. I won't get into those on this presentation. But commissions is something that often surprises employers. So, you know, they're not paid hourly, they're paid on a commission. It's still required that, number one, that you're recording the hours worked. And number two, even if the hours worked, you say it's at their discretion, it's still a requirement that you record the hours worked. And it's still required that their paycheck be no less than what minimum wage would pay. So it's if the commission doesn't meet up to what minimum wage would pay, then you need to top that up. And you can't carry over commission that was really high in one pay period to another one where it wasn't high. It has to be within that pay period. So as I said, there must be paid wages for all work performed, and work includes training, staff meetings, travel time between job sites, and on-call work. What's important about that is employers often don't know that you can set a different wage for travel time than other times. So for example, on a job site, you pay them $28 an hour. You're only required to pay them $15.65 an hour for travel time. But I'm going to emphasize that that's going to be with new workers. If you try to impose that on workers that you already have and you're currently paid full wages, and you say, well, now we're only paying this amount, that may be regarded as termination. So good information going forward, but I'd be very cautious about applying it to employees you already have. And then the wages must be paid in Canadian currency. They're not worried about you paying in Bitcoin, but barter doesn't work. It has to be at least 2 pay periods in each month. I'm still coming across employers who are only paying once a month. That's not okay. A pay period cannot be longer than 16 days. So roughly, you're either doing it every 2 weeks or evenly dividing the month. And all wages must be paid within 8 days after the end of the pay period. So pay period ends within 8 days. They must receive all the money that they earned within that period, not including accrued vacation time. So if you're accruing vacation, that can wait, but everything else has to be paid out. I recently saw on a commission complaint where the employer was paying commission based on cash flow. That's not okay. You can't use your employees' wages to help with the cash flow of your company. And then 2 exceptions are if you terminate an employee's employment. I hate the idea of terminating an employee. It sounds very final. But you terminate their employment, all outstanding wages, including vacation paid accrued, has to be paid within 48 hours. So if you terminate their employment on Monday morning at 10 a.m., then by Wednesday at 10 a.m., they must have received it. You can't say, but Friday's a regular check run. That's when we normally do payroll. You're going to have to do a manual check. 48 hours is the limit. It's generally easier if you're going to terminate somebody, have the check in hand and just make it clean. If an employee quits, you have 6 days to pay. This is an example of a wage statement. I'm not going to go through it. If you're dealing with an accountant or you have proper payroll software, your wage statements are probably fine. Some people, some employers are cutting corners, and as a result, they have wage statements that are acceptable. While you're looking at Section 27 of the Act to see that your wage statements are up to scratch, please have a look at Section 28 as well, which lays out very specifically what your your employee records need to be. You're required to have those. If there's a complaint, it is the first thing we will be asking for. If you don't have them, then there's going to be a penalty involved. It's really in your best interest in a bunch of different ways to have proper records. for employees. And as I say, Section 27, Section 28 of the Act. Deductions that are allowed on a paycheck. Well, the statutory deductions as determined by federal law, income tax, employment insurance, and CPP, those are federal jurisdiction, but the Act, our Act specifically allows for it. And then if you have, again, written consent, union dues, medical or dental benefits, charitable donations, pension, superannuation plans, excuse me, that the employees contribute to. What you may not have, even with written permission, is deductions for dine and dash, for credit card fees on tips, for breakage, for shortage in the till, or for special clothing and uniforms. And the reason that you can't deduct those is you're not allowed to ask an employee to pay for any of those. Those are all employer expenses. So recovery of advances and overpayments also require written consent of an employee. So an advance might be cash advance that you allow. It may be an employee that wants some merchandise that you sell and wants to buy it on credit where it comes off the paycheck. Just at the time you agree to it, make sure you get written signed consent for which paycheck it's coming off and the amount that it's coming off. And then overpayments, if on the employer's end, there's been a mistake and they were overpaid, you're going to need to negotiate how that's coming back. Again, you've required written permission from the employee. They weren't entitled to it, I get it, but it's also they're not their mistake. So it's important that you negotiate, get their written consent before recovering that. Employment agreements. So rule number one is it has to comply with the Employment Standards Act. I wouldn't say a majority, but certainly probably 40% of employment agreements that I see, there's at least one or two clauses in that that are not in compliance with the Employment Standards Act, and it's just not enforceable. Section 4 of the Act just says right out of the gate, any agreement to waive those requirements has no effect. So your employment agreement is null and void, or at least that section is. You cannot waive your rights under the Employment Standards Act. People try all the time, it never works. And then hours of work and overtime. If you are, if your company, your organization is involved with averaging agreements, either you use averaging agreements or you're contemplating averaging agreements, please put a note in the chat and I will address them very specifically at the end. I don't want to go down that rabbit hole unnecessarily, but if anybody is either contemplating or currently using averaging agreement, there's some important information. Regular wages are payable for up to 8 hours a day, 40 hours a week. Daily overtime, time and a half after 8 hours, double time after 12, and then weekly as well. Even if you didn't get into long days, after 40 hours have been worked in a 7-day period, which starts Sunday, then 40 hours after that's time and a half. Short haul and long haul truck drivers have different standards for us. There's also an exception for managers, farm workers. Managers, I'm just going to put a caveat with that, is there's lots of people who have the title manager, but don't meet the legal definition of a manager. So just because somebody has the title of manager doesn't mean you don't have to pay them overtime. Daily minimum hours. So this applies if somebody's scheduled for work and they show up for work and then they get sent home early. So if they show up and they're scheduled for 8 hours or less, you're required to pay them 2 hours. You can have them work that 2 hours, but you're required to pay them at least 2 hours on that day. If they're scheduled for more than 8 hours, then 4 hours is the minimum that they have to be paid. Two exceptions. If it's an event beyond the employer control and they're scheduled for more than 8 hours, then you only have to pay them 2. So for example, I don't know where you are, but it's snowing pretty good outside right now. If you were saying, we're going to close up and send everybody home for safety, then you'd only be required for the 2 hours of in that case, because it's an event beyond your control. They show up. Maybe you had somebody who was going to backfill for somebody else and that person showed up. You've got 2 people. Still need to pay them at least the 2 hours. an employee unfit to work or in breach of company or WorkSafe BC policy. So you require them to show up with their uniform. They showed up, they don't have their uniform. They didn't even bring their uniform. It's fine to send them home and say, you're not working today. And no, I don't owe you the 2 hours. If they show up unfit for work, so they're stoned or they're hungover, and it's not safe to have them do their work, send them home, that's on them. I'm just gonna cough, so I'm gonna mute. Excuse me. Meal breaks. So this is where I remind you that employment standards sets minimum standards, right? These are the standards you can't go below. It's not best practices. And if you stick to the minimum standards, there may be at times issues with hiring or retaining. So meal breaks, at least 1/2 hour unpaid break after 5 consecutive hours of work. Usually people do it at 4, but after 5, it's required. But if they're required to do any work during the break or be available during the break, then it's paid time. You need to pay them for that. So for example, I dealt with a case with a warehouse worker at a mine. They worked the front desk. So when people came in to pick things up, wasn't necessarily that busy. So they just said, you know, at lunch, if you hear the bell, just come out and help somebody. So that person was on call, and that was overtime all the time that they were supposedly on break. There is no requirement for paid coffee breaks in BC. Again, maybe a recruitment or retention issue, but it's not required under the Employment Standards Act. And then between shifts, it's mandatory 8 hours off between shifts, except in an emergency. And there is no other exception. It's not like you can pay time and a half or double time or something. They need the 8 hours off. 32 consecutive hours free from work each week is also the standard. Now that one you can get around by paying time and a half. So you have somebody working, I don't know, 2 hours a day, 7 days a week. It's not a lot of time, but they're now working through that 32. They don't have 32 consecutive hours free from work. So during that 32 hours, you would be paying them time and a half. Statutory holidays, we all like those, unless we're paying for them. I think everybody's familiar with these. The exceptions that I'm going to point out is Easter Monday. Lots of people give or take that, but it's not statutory under the Employment Standards Act. And Boxing Day. Again, lots of people treat that like a stat holiday, but it's not. And Truth and Reconciliation Day at this point is not considered a statutory holiday, although many employers give that. Statutory holiday pay. So to be entitled, it's not a full-time, part-time. It's if they've been employed for 30 calendar days or more and have earned wages or been paid vacation pay in at least 15 of the 30 days prior to the holiday. So you have somebody that works 8 hours a day, 3 days a week, they're not going to qualify. You have somebody that works 2 hours a day, 4 days a week, they're going to qualify. Statutory holiday pay is worked out as an average day's pay, where you take the last 30 days, you add up how much they made, how many days that was spread over, divide the two, and you add up with an average day's pay, and that's how much is owed for stat holiday pay. It's really easy with people who just work 8 hours a day each day, but for people with variable shifts, that's how you do it. If the employee is required to work that on a stat and they qualify for stat holiday pay, then they both get the average day's pay for their stat pay and time and a half for up to the first 12 hours on the stat holiday for the time they worked on the stat. Vacation. So earned vacation it's earned in the first year and it's payable in the second year. Now, most employers and most people work it out so that it's used in the year it's taken, but not always. So in year one, you can work through the full 12 months and just accrue. It's going to be a minimum of 2 weeks. Employers are free to give more, but it's going to be a minimum of 2 weeks. And then in the second year, you're not only entitled, but you're required to be able to take 2 weeks. It doesn't have to be 2 weeks in a row, but it has to be 2 weeks. And after 5 years, then it's 3 weeks free from work. So Important to understand here is that you cannot waive away your vacation time. So you can't say, just pay me out. I'm just going to work through it. You're required to take the 2 weeks. And an employer can't say, I'd like to pay you out. I can't spare you. So I'm going to pay you out and you're not actually getting your vacation time. That's not acceptable. They actually have to take the time. Vacation pay, it's the 4%. The first 5 years, 6%. After 5 years, it's common for employers to do more than that, but that's the minimum. And you can pay vacation pay on each check if both the employer and the employee agree to that in writing. Compensation for length of service. When I was an employer, this is something that I misunderstood a lot. People commonly refer to this as severance pay. Severance is slightly different. If severance is in common law, it's awarded by a judge, but it's similar to the idea of compensation for length of service. And in fact, compensation for length of service is automatic, but there are exceptions where an employer may not be required to pay it. So I always thought of it as if you messed up on terminating somebody's employment, then you pay it severance. And it's kind of the other way around. It's automatic unless you qualify for the exemption. So in the first 3 months, there is none required to be paid. On the first day of the 4th month, they've now kicked in. It's now a week. After 12 months, it's 2 weeks. And after 3 years, it's 3 weeks. And then a week per year to a maximum of 8 weeks. It's not required if an employee quits or an employee retires. It's not required if an employer provides written working notice instead. So let's say they would qualify 2 weeks of compensation for length of service. If you give them 2 weeks written notice instead, and again, must be in writing, then none is owed. Or if an employer is able to prove just cause for dismissal. Protected sick leave is something that's new as of this year, January 1st of this year. So after 90 days of employment, employees can take up to 5 days of paid leave and 3 days of unpaid leave in the employment year. So the employment year is based on the employee's start date, right? So their particular year, employment year, 5 days leave, it does not accrue over time. The employee is entitled to this. The employer can't say no. No notice is required, of course. And they have to give enough information to reasonably satisfy the employer that they're entitled to the leave. I would caution you that I think the days of requiring a note from a doctor are behind us with the pressure on the healthcare system and the amount of time it can take to get a note from a doctor. It's not necessarily considered reasonable. And the other thing is any part of a day that is taken off under this leave counts as a full day. It goes in full chunks. So somebody takes an afternoon off and they want it as one of the 5 days, it's a full day, okay? And the average day's pay is calculated the same as for stat holiday pay. So as Katie said at the outset, I am an investigator and I've investigated hundreds of complaints that come in from almost entirely ex-employees, but certainly employees. And I have seen lots of cases where employers intended the best, but there were mistakes that they made along the way that ends up with them having to pay out. So here's some tips from an investigator on how to avoid that. First, detailed record keeping is your best friend. First of all, at an absolute minimum, the records required in Section 28 of the Act. But go beyond that, go to recording anything that was agreed to, discussions that you had, anything of relevance. I had a complaint from a very credible presenting employee And the complaint was a fairly serious one, where the Act provides for a make-whole remedy. In other words, they would have not only been paid for all the time they lost, they would have been paid for up until they were fully employed again, plus interest on that, which, as you might imagine, could become really expensive. And in that case, as I say, the complainant came across as extremely credible, had researched it extremely well, but the employer had meticulous records of every discussion, every agreement, every time the person had called in sick, every time the person had declined to come into work, and so on. And it was actually quite straightforward to resolve that case, and the employer didn't have to pay anything because her records were meticulous. So err on the side of better record keeping. You don't know when it's going to really matter. And lots of cases as well I've had where there's great rapport between, especially in small businesses, great rapport between the business owner and the employee, and then and they're absolutely stunned when later the employee makes allegations, but they never kept any records of anything, and so they can't prove their case. So keep in mind that it's in most cases it's on the employer to prove the case. Second thing is understand the employment-related rights and responsibilities, including human rights, employment standards, and WorkSafe BC. It's a lot, I know. As I say, I was once an employer, so I get it. There's a lot going on. There's a lot to know, and none of this is about making your business work, but it's the arena that, as an employer, that you're working in, and it will pay dividends to be aware of those things. Third thing is learn how to have difficult conversations. I would say at least half of the complaints we get about termination of employment would not have happened if the employer was able to sit down and have difficult conversations along the way. It's never any fun, but taking a coaching approach and a direct approach and having those difficult conversations is not only the way to go, but will save a lot of grief later that happens when trying to skirt those difficult conversations. And finally, understand the process of terminating employment. So terminating many large companies, most large companies, even if they have cause, unless it's incredibly egregious, like theft, where it's cut and dried case like that, the employer will still pay compensation for length of service rather than try to go through the process of proving cause. But if you're going to go that route, the main thing to keep in mind is to treat the employee not like they're on their way out the door, but like they're an employee that you want to keep. And that with a little more help and coaching is going to see the light and is going to be able to change their behavior. So you need to show them the standards that they need to meet. Then if they fail to meet those standards, you help them understand how they're not meeting it, what the standards are, and what they need to do to correct that. If they continue to not meet it, they need to have that pointed out. And at that point, you can say, this is pretty serious. And if you don't meet these standards, then you will face discipline up to and including termination. They have to have that warning. And they have to be given sufficient time to correct. And then if they still fail to correct, then if you've documented it properly, you say, well, I showed you what to do. I was clear about the standards. I corrected you. I gave you the warning. You're still not doing it. I have no choice but to terminate your employment at this point. And sometimes what will happen is because there's tension along the way between the employer and the employee, the employer starts looking at the gate ahead of time and moving directly to that. And I see that I'm just about out of time. And I'm just about out of slides, so that works well. Complaints, people have 6 months from the alleged contravention or the last day of their employment to file a complaint. It doesn't mean that you as an employer are going to hear about it shortly after that. We have a backlog at this point of, I believe, over 3,000 complaints. So it takes a while to get to that. And then wages can be recovered from the last 12 months of the employment or 12 months from before the complaint was filed That's how far we can look back. That's the limit of the liability, except remember with vacation pay, it's the year previous. So in that case, we would look back 24 months. Investigation, complaint comes in, somebody like me investigates, we get evidence, people have the opportunity to respond, see the evidence that's in, the opportunity to resolve the complaint voluntarily. If that doesn't happen, then it goes to a written determination. And if the employer is found to owe money, then at that point, interest is added and penalties are added as well. And that's our info line. And that is that. And I'm hoping that there's questions.
Thank you so much, Mark. I learned some very good information in that, and I thought I was fairly up to snuff, and I definitely learned things I didn't know. So hopefully everybody else learned something as well. And now I really do want to encourage you all. Absolutely. If you have questions, now's a great time. Feel free to type them in, put them in the chat. Or once again, if you prefer coming on audio, if that's a bit easier or more comfortable for you, you can absolutely go that route as well. So please don't hesitate. It's a nice safe space here for everybody. I'm pretty sure that, you know, we encourage questions. There's no such thing as a stupid question. So really, we do welcome you all to share thoughts or ask questions of Mark while we have him here with us today. Just as a reminder, if people are thinking of questions, Debbie, I just wrote you in the chat. Thank you for sort of reminding me and everyone else. If you do want a copy of this recording of the session following today, just shoot me an email and I can send you a copy of this recording. My email address is just in that chat as well. So Shauna, I see that your hand is up. Thank you so much. Please feel free to unmute yourself and ask your question.
Hi, everyone. Thank you very much. I really appreciated the presentation. My question is, once an employee has been laid off, like for instance, you lay off a program manager, how long after can we either rehire for a program manager, or do we have to restructure that program or that employee program? Thank you.
It's a great question, Shauna. So first, I didn't touch on layoffs at all. So first of all, layoffs can happen in two different ways. The one is you have the agreement of the employee that you're laying off to be laid off, or you work in an industry where that is standard. So for example, in logging, it is common both during high fire season and during spring breakup to shut down for a period of weeks until you get through that. And so layoffs are a standard part of that job or that industry. If you're not in an industry or where layoffs are a standard part of that, or it's an occupation where layoffs are a standard part of that, and you don't have the written agreement to it, then it's considered a termination without cause. And so at that point, you're not laying them off, you're actually terminating their employment. So if you get their agreement and lay them off, or it's an industry where an occupation where that's a standard part of the cycle, then 13 weeks later, if they have not been recalled to work, then now it automatically rolls over into a termination. So at that point, it turns into a termination without cause. And that in either one of those triggers is enough that you would need to pay out a compensation for length of service for the formula. Does that answer your question, Sean?
I have an additional question regarding that same question.
Excellent.
So if you lay someone off because, I don't know, you lay them off, but you want to hire someone in a similar or the same position, are you obligated to offer that to that person that you laid off prior to posting? Or that's where my question goes from her original question.
Okay, so There is not a right of recall outside of a union agreement. So if it's non-unionized, then there's no automatic right of recall. But understand that you didn't lay the person off, you terminated them.
Thank you.
You're welcome.
Megan, I see that your hand is up as well. Did you have another question around what's being chatted about or something different?
Something different. Can you hear me okay?
Absolutely. Go ahead.
Perfect. And thanks, Katie and Mark, for putting this on. So my question is specific to, we talked about the pay and the 2 hour and the 4 hour minimums. Now in our department, we provide some online courses prior to on the job training at our retail locations. Now, what we've done is we do pay new hires for this time. What we've done is basically an average of how long that course takes. Now, my question is, if that course takes one person 2 hours to complete and someone else 8 hours to complete, are we entitled, or are they entitled to the pay for the time it took them to complete the course? Or is our average of what we've been told the course roughly should take, is that an appropriate method of payment? Just want to make sure we're on the right side of this.
It's an appropriate method of payment as long as it meets the minimum wage for the entire time it took them. So it is one of the challenges that employers faced as during and post-COVID, with more and more remote work being done. So it's similar kind of challenge to what you have there, which is how do you know how much work they actually did? And it's an important question, but it's your question to solve. And whether the course is something that their participation can be monitored, whether it's screens changing or something happening, that some involvement, the person is sitting there interacting with it. And then if it's taking them 8 hours and it should only take 2, that may be a question for you to resolve in terms of either the appropriateness of that kind of training for that person, or the appropriateness of that person for the position you have intended for them. But some people really struggle with that, and while they are training, they are working, and they have right to being paid.
Okay, fair enough. Thank you. Appreciate that.
Thanks,
Good
Megan.
question.
Yeah, very good questions. Shauna, did you have an additional question you wanted to ask as well? Or is your hand just still up from before?
Sorry, my hand's still up. I'll just.
No problem. For anybody who's maybe not super familiar with the raising of the hand icon, you can find it on your bottom options bar under reactions. You can feel free to click on the raise your hand, and then when you're done, you just click that same button to take it off. But it's no problem at all. I do it every day. So I think what I'm going to do is I'm going to jump to the chat for a couple minutes, because we have had a couple questions come through in the chat from Mark. So Mark, the first one I'm going to ask is, does vacation pay owing need to be paid within 48 hours?
Absolutely. Of termination of employment. If it's the employer terminating the employment, that's part of what must be paid within 48 hours. Any money owing must be paid at that point. And so that would also include expense reimbursement, right? If that's part of the issue, any money owing has to be paid.
Interesting. And so also like time in lieu or anything else?
Yes.
Like that. Okay. Perfect. And Sharon, let us know if we're missing, a key component of that question. If there's anything in addition to that, let us know. What else? There was another one. Oh, Sharon also had a question. Do young workers need to be supervised if completing light work?
I don't know the answer to that right off the top of my head. Give me a second here. See if I can find that. That'll be in the regulation.
Thank you, Mark. Yeah, that's a very good question. And once again, everybody keep them coming. Really good questions. I see a few more coming in the chat. You're very welcome, Carla. Now's just such a great time. If you've ever had a question, please don't hesitate. So feel free to keep typing them in the chat. And after we've answered all the questions in the chat for a few minutes, I'll come back and open up the floor again for people who prefer to share through their audio.
So if they're under, if they're 12 to 14, then they must be supervised both directly and immediately. That means not in the vicinity, that means right there supervising is what the regulation says.
So age 12
Supervising a
to
young worker.
14.
Age 12 to 14.
So when they're 15, they can be unsupervised doing light work?
Under our legislation, I don't see an issue with that. I suspect you have the potential for contravention of OH&S on that, depending on the situation. They shouldn't be working alone at that age under
And Mark,
OH&S legislation. I'm
Mark,
guessing.
I think there's a stipulation around that they have to be supervised by an adult as well.
Absolutely
I might be
correct.
wrong on that, but I believe that's so they can't be supervised by somebody who's not an adult that might be in a supervisory position.
Thank you for catching that. Absolutely. They have to be at least 19. You're absolutely right.
Yeah.
Thanks for pointing that out.
Thanks, Zach. Okay, so I'll jump back to a few more questions we have in the chat here. Janine is asking, ESA doesn't speak about severance. Is there a way to become educated about how this works?
So severance is, our version of severance is compensation for length of service, right? So that's section 63 of the Act. And that was that part that I described, where, you know, if they've worked 4 years, they're owed 4 weeks of pay with certain exemptions. Severance is the common law version of that. And severance is quite a bit more complex. And it has to do with everything from the person's age, hireability, the time that they were there, all those kinds of things. And that the award may be many multiples of what compensation for length of service is. But that is a discussion for an employment lawyer.
Thanks, Mark. Moving on, what are the timelines for record of employment after termination?
So record of employment. So all employment records are required to be kept for at least 4 years. Yeah, so you can rotate that if the person's still employed, but yeah, 4 years is the requirement.
I think she might be asking what the requirement is from the employer of when they need to get a record of employment to the employee after the termination.
Thank you.
I think,
If
yeah.
that's the question, then I can say the record of employment is federal jurisdiction, so that's not through us at all.
Okay. Megan is wondering, does employment standards provide a metric for work alone policies or procedures?
No, that would be WorkSafe BC, occupational health and safety.
Okay, perfect. And you have put those links in the chat, correct, Mark? Or is there one there for WorkSafe?
I did not put for human rights or WorkSafe. Yeah.
Okay. I'll see if I can find a good link for people before we finish up today, and would be happy to share that in the chat as well. So Natasha was asking, so high-tech workers and being exempt from parts of ESA, part 4, if the employer offers time off in lieu as not required to pay overtime, and then revokes this benefit at some point, can the employee ever come after the employer?
They can always come after the employer. What will the decision will be dependent on the facts of the case. So we get, for example, people claiming high tech that don't qualify for high tech. It always comes down to the fact that the facts of that particular case. So I can't provide a specific answer to that other than say that a complaint can always be filed. just whether they'll succeed at that. That would be the defense, that we're actually not required. But the facts of the case matter a great deal. This is if any of you call the information line, this is one of the to ask questions related to employment standards. This is one of the tricky things that they have to face, is they're dealing with the facts as presented and not a full investigation package. So they will often give information based on the facts that are presented the way it's described. And then when a complaint is filed and an investigator like me looks into it, the facts turn out to be quite a bit more complex than they were described. And people will get upset because the answer is quite different than they got on the info line. But the reason for that is the facts of the particular case matter so much that you can't give general answers that are going to stick in every case. And it really depends on how much was presented and how much was the way things were asked.
Thank you, Mark. Megan's asking, are past employees entitled to their employee files after they have been terminated? If so, what information must be provided to them?
It's a great question. I would look under privacy legislation for that. There is nothing under employment standards legislation for that. Now, that said, if an employee or former employee files a complaint and we investigate, we're going to be getting copies of your employee files for that person. And part of the investigation, particularly if it goes all the way to an investigation report, part of that investigation will be cross-disclosure, so they will get a copy of all those files at that point. But again, there's nothing that specifically says the files are required to be disclosed. That wouldn't be under our legislation at all. I don't know if it exists anywhere, but privacy legislation is where I would look. And then under our legislation, again, after 6 months after their employment ends, then we wouldn't even investigate a complaint.
Thanks, Mark. I put a couple of additional links into the chat, one for WorkSafe and one for Government of Canada Human Rights. So those might be a couple of websites you can check out if you're looking for some additional information that falls a little bit outside of the purview today. But what I'll do is I'll jump back over to sort of the audio option and just ask, is there anybody else who would prefer to ask their question through audio? You can raise your hand, you can just unmute yourself and share if you like. Now is a great time. So I give anyone else the floor who'd like to unmute and ask a question. Also, don't hesitate to keep the questions coming in the chat as well. Just skimming through. Oh, thank you, Mark, for adding in that link. BC Human Rights. You're right. Yeah, I had the federal site.
It's all good.
I don't see any raised hands. That can't be it. Have we covered it all? We're at 3:01. So just as a reminder, we did have the session booked for an hour and a half today. So we are booked until 3:30. I understand if anybody does have to start leaving shortly, but we do have additional time that we have quite purposely built in for the session, just in case there was a lot of questions. So once again, please don't hesitate, put it in the chat, unmute yourself and share. Please feel free to ask. Maybe as people are thinking, Mark, is there anything else that has come up for you just in what we've been talking about thus far and in the questions we've had thus far? Is there anything else you think you'd like to share?
Just, I'm just thinking through what has been common in terms of the complaints that I get. some of the interesting files that I have going right now was a employer who, it appears, neither party is being particularly forthright, but it appears it was a partial paycheck, partially cash under the table arrangement. It is deeply problematic for the employer because, of course, they don't have records of the pay, but the employee kept records of the hours worked. So it's whenever it's one wanders away from the straight and narrow, there's liabilities that go with it. I understand the temptation, but there's liabilities that go with that. That can be a real problem that can bite you later, and commonly do. So
I'm going to come to Sharon in a moment because I see her hand is up. But Mark, just to ask a further question to what you just mentioned, is the onus on the employer, like, for example, if there is some kind of contention, like you were just talking about, where the employee is saying one thing happened and the employer is saying another thing happened, is the onus really on the employer to have the records and have the proof? Is there a general sense of, things may be awarded to the employee if there is a lack of proof provided from the employer, or is it really just a case-by-case basis?
well, it's always case-by-case basis, but meticulous records will protect an employer. It's if you're doing what you're supposed to do and you kept meticulous records, you're going to be fine. In cases where the records are not well kept, and yeah, it's predominantly on the onus is predominantly on the employer. So there are cases, for example, I dealt with one quite recently with a remote worker, and there was a substantial disagreement over the hours worked. And so in that case, there was considerable onus on the employee, the complainant, to show that they worked the hours. Like they need to be able to do something to substantiate it. But once they give something to substantiate it, it then turns to the employer, right? And given that hours worked for each day worked is part of the records for the employer, if you're missing those, we're just going to go with the best available evidence, which is what the complainant said. Right. So best available evidence, but that's also part of my job as an investigator is to kind of dig behind the stories and look for, sometimes there's creative ways of providing evidence. So recently I had a complainant who was able to use, depending on your settings on your phone, Google Maps. If you don't have the privacy settings cranked up, then your timeline in Google Maps will show everywhere you've gone and what time you were there for how long. So he was able to establish that he was at the place of work all the time he said he was, right? So even though there was no time clock or anything like that, he never wrote it down. He was able to use that to establish that he was at least at that place, right? So it's sometimes we look for creative ways of doing it, but a decision will be made with the best available evidence. And if the employer hasn't kept the records accordingly, then what the complainant says is going to probably stand.
That's very interesting to hear, actually. And sort of a good reminder, with all the increasing sort of technology and different platforms that people are using, absolutely people can get creative with providing that proof. Okay, so I'm going to hand the virtual microphone over to Sharon now. Sharon, I think you had a question. Please go ahead.
I do. It's about criminal background checks. I know that we can make it mandatory as a condition of employment, but I know that human rights sort of gets into it when we talk about not making a hire based on the results. What is the legislation behind that? What can we say and what can we not say?
I wish, Sharon, it's such a good question. I wish I could provide you with an answer to that. That is human rights legislation, and it's going to be in the area of common law. So an employment lawyer is who you want to talk to about that. So an employment lawyer with experience dealing with the human rights side of it. is going to be able to give you. It's not under employment standards legislation. So I would be wildly out of my wheelhouse to attempt an answer at that. Sorry.
Okay.
That is a good question though, Sharon.
It's a great question.
And Shauna as well. Did you have a question?
Hi, yes, this may be related to human rights as well. However, when we are submitting a job posting, we are, for instance, we are the Aboriginal Friendship Centers, and we then can indicate, I believe it's section 21, or one, that we preference is given to someone with Aboriginal ancestry. Am I correct, or do I need to then refer to the human rights clause?
That would be a human rights question. It's not covered under employment standards.
Thank you. Yeah, that's what I thought. Thank you.
Sorry.
Thanks, Shauna. Okay, just jumping back to the chat for a moment, I did see a comment or a question about breaks. So Natasha says, lunch break is supposed to be within the first 5 hours of work, or is it after 5 hours? For example, an employee working 5.5 hours.
An employer must ensure that no employee works more than 5 consecutive hours without a meal break. So if they've worked 5 hours and 1 minute, you've gone over. It's, you know, it's if I can speak for a minute about an approach to legislation, and that is it's worth taking the time to become somewhat familiar with the act and the regulations. As somebody who works with it every day, I still go back every time I have a question. I was trained early that you haven't read the act until you've read it in the context of the question that you have in mind right now. And so it's always worth going back and just saying, I think I know this one, but let me check. And you'd be surprised how often it surprises you that there's some aspect that applies that you had never noticed before because it wasn't this question that you were asking.
Thanks, Mark. I wonder if it would be beneficial if we brought up the website at all and we could show people how easy or maybe how challenging it is to sort of look up specific items within the act, because I'm assuming that there's a search bar and you can just put in a keyword and it would hopefully bring up the section in which that's mentioned. Haven't done it myself in a while. Does that sound accurate?
I'm happy to do that. Just give me a second and I'll it's yeah.
Perfect. Sometimes it can be a bit intimidating to think of, you know, well, if I have to go and search this and find what I'm looking for in an act, you know, I don't know if I want to spend the time or the effort to do that because it might be quite the process. So yeah, that'd be perfect. If you don't mind maybe sharing the website and just showing people how they could best do that. I think there could be some value in that.
So yeah, you're seeing, I'm hoping, a screen that's titled the Employment Standards Act at the top right here.
Yes.
So it starts with the table of contents that's all hyperlinked, right? So with titles for each section, so hiring employees, wages, special clothing, so on. And it's really a matter of going down and clicking on any of these. Just a second here. So I'll give an example. And regulations are the same. So I'm assuming you can see, you just saw that jump to
Yes.
regulations. Okay, great. So I'm going to show you here because I saw the question come up. So regulations, if the regulation doesn't show up in the act, it's worth looking in regulation. So here we have the definition of a manager, right? If we wanted to find overtime, hours of work and overtime. Meal breaks, that's where the answer to that 5-hour question is. It's about split shifts, the minimum daily hours, maximum hours before overtime applies. Hours free from work. Agreements to average hours of work. That was the, I mentioned earlier, averaging agreement, but it sounds like nobody on the call is doing that, which is probably a good thing. they're almost never done correctly. So it's good to avoid those. So it's fairly straightforward, you know, going down through here, just in the titles. There are, that said, a couple of things. So one of the things you can look in terms of a search is if you just Control F. I want to see what it says about pregnancy. I don't know what all applies, so I'm going to have a look through that. So
Absolutely, Control F. I was going to mention that, Mark, if you didn't. So I'm sure a lot of you are pretty familiar with that option, but if you want to, search for a keyword within a document, Control F is really handy to be able to do that. And then like Mark just showed, it will highlight everywhere in that document. It has that word listed. So that can also help you to maybe jump right to the information you're looking for and not have to spend a lot of extra time scrolling. Thanks, Mark.
So, you're welcome. It's also a really good way. Remember, I was saying at the beginning that it's really easy to miss sections that matter, right? That it talks about it somewhere else, not just in the section you're looking at, and you wouldn't necessarily know that. And that's a good way of checking for that. It's pregnancy is one of those ones I like. There's a very odd placement on I think it's section 54. Just in the middle of something entirely different related to leave, it throws in that you can't terminate the employment of somebody who's pregnant, like for being pregnant. And you would think that's a human rights thing, or it would be somewhere else, but it's right in the middle of talking about something completely different. There you go, it's section 54, which is talking about leave, and it just throws in must not because of an employee's pregnancy or leave allowed by this part. So most most of the contraventions of the act are fairly straightforward to rectify. There's a small number, and this is one of them. There's a small number, protected leaves, terminating somebody because they're pregnant or misrepresenting a job are ones that can get where it's a make whole remedy. So those are contraventions you want to make sure that don't happen. That can get quite expensive.
So just while Mark has the site up, does anybody have a question that's specific to the document, the website, sort of searching information, anything in particular around that? To the Employment Standards Act? Okay, if not, I'll move on. So, and Shauna, I'm going to come to you in one moment, but Mark, somebody was asking for the helpline number again.
Sure. So it's 833-236-3700.
I'll just put that in the chat for everybody.
Excellent.
Perfect, thank you.
And it's a multilingual line as well. So if there's a language you prefer other than English, they can probably help.
So Shauna, I'm going to jump back to you, or is your hand still raised, or is this a new question you've got? It might have still been raised from a previous question. Maybe Shauna stepped away for a moment. So what I'm going to do is jump back to the chat because I do have a question from Tanja. Mark, are short and long haul truckers entitled to sick leave?
That's a great question. I don't know the answer to that offhand. So first of all, long haul truckers, if they're crossing, the first question is, are they crossing provincial or international borders or boundaries? If they are, then it's not our jurisdiction. So there's the first one. And then let's have a look. I don't know the answer to that. I would be surprised if they were exempted, but let's find out.
And Tangent to say in the chat, not crossing borders for the purpose.
Not crossing borders. Okay, so long haul within BC. Yep, fair enough. So in part 7 of the regulation is where the exclusions take place, right? So and then so exclusions can be, you know, either the entire occupation of the profession is excluded or certain employees are excluded. I'm assuming that you're looking at my screen here with the regulation. And then how it applies to different. So here we go down to truck drivers. Truck drivers, section 3540 and 42.2 of the Act. So we go back here. 35, maximum hours of work before overtime applies, doesn't. 40, overtime wages. 42, banking of overtime wages, none of those apply. For overtime, time bank. It does not say that there's an exemption for sick time for long haul or short haul truck drivers. So if there's no exemption, then it applies.
That's good to know. Mark, we had another question. It says, thanks for the clarification on lunch breaks. Since they're mandatory, what do we do if employees don't want to take them? Are we supposed to enforce them?
Well, it depends if you want to pay time and a half during that period. If you don't mind paying time and a half, don't enforce it. If you don't want to pay time and a half, then you don't need to enforce it. Or sorry, then you need to enforce it if you don't want to pay time and a half. It's basically how it works. If they're a salaried employee, depending how the employment agreement is written up. So typically there's elasticity on the hours for a salaried employee, because if they work 30 instead of 40 hours, then they're going to get the same amount. If they work 50 hours instead of 40 hours, they're going to get the same amount, unless you specify in the employment agreement. And again, this is where I say it always depends on the specifics of the case. If it says salary for, you know, let's say 80,000 a year for 40 hours a week, then any variation on the 40 hours is going to matter. And so that'll matter for lunch breaks. If it's salary 80,000 a year and there's elasticity in the hours, then, and they want to work through their lunch break, it's, you know, really that's up to you, because they're not going to qualify for overtime. If they're hourly, and I get that, I have a hard time taking lunch breaks myself. If they're hourly or if their salary is tied to a specific number of hours, then it really depends. Because if you allow somebody to work overtime, then you pay overtime, even if you might have a policy that they have to approve it, or that you have to approve overtime before they do it. Well, that doesn't matter as far as the law is concerned. If you allowed it to happen, then you pay. Excuse me.
Okay, thanks, Mark. So believe it or not, we're actually approaching that 3:30 mark. We've got about 10 minutes left. So once again, I just encourage you, feel free to raise your hand, unmute yourself. Now, Natasha, I thought I just saw a raised hand, but then it disappeared on me. So you might have already had your question answered or didn't have the question anymore. But if you still do, please let us know. Or any other questions in the chat that anybody has come up with. If not, what I'm going to do is just repeat Mark's contact information in the chat as well as my own. So give me a moment and I'll make sure that gets in there. Yeah, and you know, anything else you'd like to share with us, Mark?
No, I just wanted to special shout out to Zach for pitching in on a couple of those. That was great. Thank you.
Yes, thank you, Zach, and thank you, everyone. It's not copying and pasting quite the way I'd hoped, so just bear with me a moment. I'm just going to grab that information from somewhere else, but I just want to make sure you have it. Once again, please do email me. If you do want a copy of this recording, if you've just requested it in the chat, you probably won't get the recording sent from me. So please do just take a quick moment, take my email address down. I'll put it in one more time in the chat, just to make sure everyone's had the opportunity to get it. But yeah, please do send me a quick email if you want a copy of today's recording.
I'm going to weigh into one other thing that I've just remembered, if you don't mind, if we have,
Oh,
we have
please.
a minute. So one of, it's not extremely common, but it's not uncommon. It's not rare by any means, is the dispute between whether the complainant quit or was terminated. If you have somebody, when you have employees quit, it's a good idea to get it in writing. If they don't want to give it in writing, then send them an email that says, you know, on this day, whatever, you know, you resigned effective this, we're sorry to lose you, we want to wish you the best of luck. Something that documents that there was communication about them resigning. We do, however, get cases where it's kind of a passive aggressive move by the employer, where they try to allege somebody quit. And as a rule, if you have to tell somebody they quit, they didn't. It's a termination. But it's one of those things you want to document, because I have had employers that I call to find out, because I've got a new complaint filed, and I call them up to find out how on what were the grounds they were terminated on. They said, no, that person quit. And it's like, okay, but it's on the employer to show that. So what do you have? And many employers just, it doesn't occur to them that they need to do that. And it's one of those areas of paperwork that you want to make sure you close off. And ultimately, if we get a complaint from a former employee that's within that 6-month window, you're going to need to show how they left.
I think we have time for one more question, Mark. So we had one come through that says, if an employee is injured on the job due to equipment malfunction and is required to take sick time to recover, would the employer pay those days, or would it then be a WCB question?
Yeah, so that is if an employee is injured on the job, it is essential that they report the injury to WorkSafeBC and do so promptly. And same with the employer. It is one of the leading indicators of workplace safety management is how well and how timely injury reports happen. But if they were injured because of something on the job, then it should be WorkSafeBC paying that for sure. An employer may or may not do something to bridge it. That's up to them, but there should be prompt reporting and prompt paying from WorkSafeBC to cover that. That shouldn't come out of your sick pay.
Okay, perfect. Yeah, you're very welcome. Okay, so just in the last few minutes here, I just want to take the opportunity to thank you all for coming. I hope you found the session helpful. If you are going to send me an email and ask for a recording of today's session, please do so. And always feel free in the same email to give us some feedback. You know, maybe you'd like to see a session that does talk more about workplace safety or human rights. We're happy to be a bridge and help book some sessions from different speakers who can give us, you know, the information that we're looking for. A huge thank you to Mark Hill. Thank you so much for being here today and probably straining your voice in talking to us for an hour and a half today. We really do appreciate your time. And yeah, anything else you wanted to add, Mark, before I wrap up here?
Just thank you for hosting this, Katie, and thank you to everybody for attending. It's even though I'm an investigator, I would always rather head off issues before they occur through education than spend the time trying to figure out how to fix it later. So thank you, everybody, for being here.
Absolutely. And once again, I did put Mark's contact information as well as my own in the chat just a moment ago. So we've had a few comments come in, but just scroll up a little bit, you'll find it there. It's always really lovely when a speaker gives us their direct contact information, and you don't just have to call and maybe get sort of a general line and try and track somebody down. So do feel free to take down our information. Thank you all so much again, and we hope you'll join us at a future session. Thanks again, everybody. Thanks, Mark.
Thank you, Katie. Take care.
Have a good rest of your afternoon, everybody.